Committee this Thursday afternoon, February 5th. We're turning our attention to H566, which we've gotten some testimony earlier this week, and we are joined by Rachel Jolly. Thank you for being here. It's been a while.
Yeah,
good to see you.
My pleasure. Thanks for having me. And I'm sorry I couldn't join in person. I would love to be there, and I'm sure I will before the session is through. For the record, my name is Rachel Jolly. I'm the director of the Burlington Community Justice Center. And cutting to the chase on 566 around the sealing and expungement issue, while expungement has felt more definitive and clear for us to communicate to our participants, we recognize and appreciate that sealing will provide the same protections for collateral consequences such as housing and employment. I did end up listening to Willa's testimony yesterday and have to agree that some kind of one-pager or plain language document would be really helpful for our staff and our participants to understand who has access to their records and when. But I also understand that's not for the statute, but I just thought I would say it here. So in summary, we're in support of that change to sealing. And then, unless there's any questions about that, I thought I would move to the municipal piece of this of 566.
Please.
Yeah. So regarding that amendment of the court diversion program to include municipal ordinances, I thought it might be helpful for the committee to hear our experience with City Circle, the name of the program at the Burlington CJC that we're calling referrals for civil criminal municipal violations. So we did hire a staff member to coordinate that pilot program. She started in November. She trained and onboarded 6 volunteers, and she launched the program on January 5th. So it's really just been going 1 month. Thus far, we have received 6 total tickets from BPD from Burlington Police Department for 4 individuals. The municipal criminal violations have been related to open containers and trespassing. 2 individuals participated in the program. I should say we have received 6 total tickets for those 4 individuals. 2 individuals received 2. And the 2 individuals participated, total individuals participated out of those 6 tickets. In the program, 3 tickets were addressed. 1 let us know that they were choosing not to engage, and 1 did not get in touch with us. So proportionally, we feel like we've had a fair level of engagement. I would say that unlawful mischief, graffiti, disorderly conduct, and public illegal drug use might be some of the other violations we expect would pick up as the weather warms. And criminal and municipal violations would otherwise go to criminal court. So civil violations would require repeat offenses to become criminal, just to kind of repeat some of what you might remember from our description of City Circle last year. And I have, as I said, I've watched Willa's testimony. I've listened to some of the questions. I would just like to say that I do believe that this does save the state resources and keeps things upstream. And I'm also cognizant of the fact that when times are tight financially, the tendency is to stay more in one's lane, perhaps, and not think about investments in upstream. But I do think that regardless, this program is saving the state money in terms of things going further down and escalating into more of a court backlog and other collateral consequences that spill out when somebody does go to the court process. But I thought I would just keep it short in terms of summarizing what's happened so far with this program. But then, of course, I'm open to questions.
So the question is, who's funding that position now? Is that being funded from the city of Burlington?
The position, that coordinator City Circle, is being funded by the Attorney General's office. And I should say that in its totality, it's a pre-charge position. So it's working on the pre-charge diversion program, including our other criminal pre-charge referrals that come from police. So,
because that was kind of, there was a couple issues with expanding to the municipal ordinances. And one was an understanding that that's really not necessarily the state's attorney. In some circumstances, it can be. It might be a city attorney for a municipality that would bring such a case, and therefore would be the entity or the person would have to okay a pre-charge going directly from law enforcement. So that was one concern. Perhaps that's not a concern specifically with the Burlington pilot, as I don't think it is. But that was a concern for having this kind of broadly. I mean, we would really need to dig into this a little bit further. And the second is just that it's not, I'm not going to call it slippery slope, but where do we draw the line as far as municipal? I know that in South Burlington and the other Chittenden County CJCs, they take on cases that aren't going to be in pre-charge. And there's been an issue of who pays for that. Could be just two neighbors, that kind of thing. So,
sure.
And does this seem more like that? I don't, and should the municipalities individually need to agree that pre-charge should occur for those ordinances and also fund those? So those are kind of the two questions that are out there.
Yeah.
And that's,
I appreciate them both. I guess one thought that comes to mind is in terms of the jurisdiction, this has been clear, and I could share, actually, I maybe should have shared in advance, the City Circle memo that went out from the City of Burlington Attorney's Office, as well as our guide for volunteers and the public, really, about the way the program works. But really, these are for violations that could become criminal, sometimes with repeat offenses of these violations or others, but are not going to the state's attorney, are going to the city's attorney, and that has that individual, the attorney's office has discretion around when to further prosecute or to send to superior court. So it could be, and our attorney has let us know that right now the only thing that the individual is getting is a ticket, a handwritten ticket. However, that would if the attorney was wanting to go further with the prosecution, that would be changed to an affidavit. So I understand the slippery slope kind of fear, or certainly net widening. I do think these are violations that are criminals, municipal, and could be turned into criminal. And so to me, it fits the definition of pre-charge and what pre-charge is about, which is a timely response, an upstream response, a response that can include the victim, more quickly and directly. So I don't know if that responds exactly to your second question and a little bit of your both questions, actually. I'll just say I appreciate the concerns and the idea of that slippery slope. To me right now, again, we're only 1 month in. We don't have really any trends to look at or any patterns of the data to examine, to talk about we do plan to further this, continue the pilot through the end of the fiscal year, as it was designed as a pilot and an experiment. And I appreciate you trying to draw in other perspectives, the Vermont cities and, this League of Cities and Towns, et cetera. But I guess that's just where I sit in terms of Burlington's experience with it thus far, and the thinking and the intention that went in with our attorney's office.
So perhaps, we recognize that this pilot is ongoing and is going to be part of the pre-charge. It seems like that's already happening. And we wait to get a little more information from that and dig in a little more deeply on this to expand this kind of thing statewide. Because I really think there's a lot more process and such that we have to dig into it. Because again, it needs to be the entity that would be taking that to court or not, be it the state's attorney in some instances, be it the city attorney in other instances. I think we have to have mapped out what kind of process for either of those entities to have a policy for what municipal violations go directly from law enforcement. I mean, so that's, and I think that that's going to take a little bit more than just being able to resolve it right now. But the pilot will go on. We'll learn more information. I don't think we need to. Do we need to have some language just somewhere in here saying that this pilot is occurring, or is that? Yeah, Karen.
Yeah, I think and I can do this. I can check in with Willa, but my assumption is when they started this pilot, it was because kind of assuming that the language did allow for this.
Right.
And I was like, well, how about we make sure the language allows for, and that's where this proposal comes in. So now that we have this debate, I wonder if that will inform the Attorney General's office, like, oh, maybe this pilot isn't allowed.
So why don't we draft a provision that recognizes or, approves or whatever it is, the pilot, so that, because it would probably be good to learn in this situation how it's working. But I do think we need to dig into this more deeply, time permits, to really have it statewide. At least that's my view. I'm happy to take different viewpoints of that.
I think that makes sense. And I like the piece about being able to confirm that this pilot can
Yeah.
continue. Yeah.
Is there any downside to putting it in? Like, might be. Right?
But there might be. I mean, we need to more fully vet it and get
Okay.
the opportunity.
Right, because I would hate for.
But let's learn from this pilot too.
Yeah.
That should tell us some information for
Right.
expanding it.
And I think along that line of questioning, Barbara, like, well, is there a downside? I think at least if we're the inclusion of some like enabling language, or I don't know what to call it, but to reaffirming language that like what's going on is good and should be going on, and we can learn from it, is helpful. I think it still holds up what's happening without trying to get into things that are other things that are happening that we aren't familiar with or clear on.
Right.
No?
And I'll forward the two
Yeah, it has
documents that I referenced before, just in case those are helpful in any way.
Yeah, no, please. Any other questions for, yeah,
I have a question that Rachel, I apologize if this is the very first thing you said and I missed it, but I was wondering, we heard yesterday, I believe it was from the Defender General, that, and we understand the Defender General's position is in favor of expungement over sealing generally. But he spoke specifically of juvenile records. And I wonder if you have any thoughts on, I'm not even sure if I guess everything's on the table. I don't know that this is on the table, but what would you see a need to maintain an expungement process for juvenile records, or is sealing sufficient?
That's a good question. From my understanding of what sealing provides versus expungement, from talking to one of our colleagues who worked in the judiciary for a couple of years, expungement still is technically, it is still recoverable by certain entities. And so I'm not convinced that sealing is that different from expungement at the end of the day. So I guess I haven't given that enough thought or spoken with our youth team around youth records, but my initial thought is that I'm still comfortable with sealing.
Okay, thank you.
anything else you want to share? How are things going generally in the Burlington CJC?
Yeah, I know you heard a bit from Willa. I do feel really positively about the time that we were given, thanks to you and the AGO, around this kind of grace period of a year to work on the transition in this county. As you can imagine, there's lots of different stakeholders and things that need to be thought out before just rushing into it. And given the year, I feel like we've been able to make good use of the time. We have 2 volunteer sessions coming up tomorrow and on Monday to hear from the volunteers of all 3 CJCs. The town managers will be at each one. And I think we have important context to explain because it hasn't been so clear about what's happened or what is happening and what the vision is. And then I'm feeling good about a collaborative visioning session around creating this new, soon to be named, perhaps Chittenden County CJC entity. And I think I do believe that we'll have the possibility of continuing really a lot of the good work that has been done, if not more, and keeping the localized nature of it, keeping our bricks and mortar locations in different towns, and maybe increasing those, given that these other CJCs haven't held the diversion contract before. So volunteers haven't been present at some of the diversion panels, or the Tamarack program restorative processes. So hopefully this will present some opportunities that hadn't been realized before for localized justice.
That's good to hear. It's great to hear. Thank you for your hard work on those efforts to County CJC up and running.
Yeah.
So really
My
appreciate
pleasure.
it. So thank you
Yeah.
very much. Anything else? Thank you again for being here.
Thank you.
All right, so we'll have Jennifer Poland join us. Good timing.
Apologies that I missed my colleague's testimony. I felt like I had to park in East Montpelier and then getting through security was a little something else.
Every day, right?
Just gonna plan for it from now on. But I've gotten back of somebody in line who had a lot of stuff. Just a lot.
That'll happen.
Hopefully he's not watching this. So for the record, I'm Jennifer Pullman. I'm the Executive Director of the Vermont Center for Crime Victim Services. And thank you for asking me in to testify yet again on the expungement versus sealing paradigm. Maybe one day it will go away, but it'll get sealed. Well, we'll see. But it won't surprise you that the center does support 566. And for those of you who've been in the room for countless testimony from the center, again, that's why I say it will not surprise you. What's been spoken to over the years that I'm referring to is that in many ways, this is a distinction without a difference. And I say that because what we've heard over the years is that the main policy goal is to make sure that people have a second chance. We don't want to get in the way of people getting a job, getting housing, those kinds of second chance pieces. And I completely understand that because most everybody is going to be out. And the most important thing is to provide successful opportunities for transitioning and for people to have those supports. And so I do support that completely because representing victims and survivors, we get what happens when somebody doesn't get that. And I think, for me, yesterday's conversation was interesting timing. Because again, I say that right now it's a distinction without a difference. Back when this paradigm was set up decades ago, it made sense because the internet, social media were not in our face all of the time. So we could expect that there'd be some level of privacy, some level where people wouldn't find out about everything that you had done. As Matt Valerio testified yesterday, privacy basically is elusive. That's not a thing anymore. So when I look at the bill, more so now more than ever when I've testified, I'm going to go out there and say it's a legal fiction because we can find this information out about anybody at any time. So for the policy goal, initially, and has been testified to over the years, sealing does only allow limited access for criminal justice agencies. And that's important to understand because there are certain things about that that are really important for the constituency that I represent. First is, when we think again about, I'm going to invoke Matt Valerio, he's a friend of mine, but we can't expunge the internet. So what are we actually accomplishing by keeping expungement there versus what are we getting away from? And as I've said before, from my constituency's perspective, the record should get as close to reflecting the act as possible. The legislature has established predicate offenses for a reason, because we want to think differently about somebody who's coming back in with a similar offense. We've also talked about in the past that with expungement in diversion cases, there could be cases, and Tim Lears-Dumont spoke to this very well a couple of years ago, where someone is repeatedly going to diversion, but nobody has any idea about that. So those are considerations that would not be at play if we went to a ceiling regime in these cases versus an expungement piece. And then there's this other backdrop. So within the past couple of decades, the internet has changed our lives, not really for the good. Social media is in our faces. But during that time, we've also changed the face of what happens or what crimes are eligible for diversion. So we need to really re-explore the notion that it used to be that diversion is only for low-level cases. And I always have an issue with what's defined as low level because it's not low level for the victim survivor in many cases. So I'll put that aside, just want to state that again. But we've also made some changes because we're trying to create an alternative system that maybe is not as punitive on its face. So, for example, Act 11, we passed that a couple of years ago, which allows domestic violence and sexual violence cases to go through diversion. We've expanded the pre-charge program as well, which gives state attorneys the ability and law enforcement to set up their own policies in terms of what's available. So, I'm thinking about two recent examples that I just want to highlight when we're thinking about what is being expunged. There was a case in Bennington where an attorney 2 years ago, well, it was in 2019, but it was relevant 2 years ago, where the Attorney General's office was prosecuting that case. And it was a sexual assault, but the case was, the charge was pled down to, I've got the article in case you want it, but it was pled down to an LNL, a straight LNL, so that it could go to diversion. I think our communities want to know that. I think our communities want to know that an attorney abused his power. And I think that's important to know. And while we're not talking about deferments, I don't want to go that road today, but there was a case in Madison County where the sheriff had allegedly sexually assaulted, and that was the initial charge. And that was placed under a deferred sentence, and that can be expunged as well. So I'm sharing examples of what can be expunged now because it's serious, and I think our communities do want to know. And it's also important to realize that the resources for supervision in these cases are not there. They are not there. You know that diversion is not funded in the way we would like it to be. Even on deferred sentences, if you were to ask corrections what they do, it's pretty minimal. So I just want to, again, have us reframe when we think about what's going through diversion, because it's not the same as it was years ago. And I'm not saying that's a bad decision. I'm not at all, because there are lots of good reasons why something wouldn't go. And sometimes it's victim choice. But I do think that having law enforcement be able to access those records when they're serious crimes, I think is to the center, it's a really important piece. And if the difference is a legal fiction now, because I can look up anybody on the internet to find out what they were doing. So if it's a legal fiction, then I think it's important to have resolution reflect the charge, reflect the act as best as possible. I'm not foolish. I know what happens with plea agreements. But again, I think that having some access to that information, and then just logistically for center, as many of you know, we operate the Victims Compensation Program and the restitution unit. If it's a sealed record, we have access to those files just for purposes of being able to enforce a restitution order or being able to provide victims compensation. As some of you may recall, we're probably maybe the only state in the country that keeps our claims open until a victim has maxed out their claim, which means that they might not seek any expenses for a couple of years because trauma looks different along the course of your journey. But if it's expunged, we can't provide any support whatsoever. So for us, and then with restitution orders, it's the same thing. And this body has done a great job in statute in terms of elevating the fact that we should not be expunging cases where restitution is owed. I'm here to tell you that mistakes do happen. I don't want to shock everybody, but mistakes happen. We had a $30,000, a case where 30,000 in restitution was ordered and the case was expunged. There's nothing we could do about that. So, logistically from where we sit, that is a distinction with a difference. So I really do support this bill very strongly for a lot of different reasons, policy-wise, logistically, and I think times have changed, both in terms of what people can access and what the crimes are that we're looking to send through our alternative process, which again, I've testified many times in support of that process, but I also don't want to see there be consequences that victim and survivor, and also that law enforcement, we have a predicate offense for different places for a reason. And when that's gone for good, it's gone for good. So thank you very much. That's all I had to offer. I was brief today.
Questions? I don't see it. I think fairly straightforward. Appreciate your testimony of that as well. Thank you.
Well, thank you for asking me in.
Yeah, absolutely. Always nice to see you. We'll probably see you next week. We're probably gonna be reaching out to you for Tuesday for quick overview on the budget requests that you have.
Great.
So we'll see you
Thank you.
soon.
Right, well, hopefully the parking's a little better. Thank you. Thank you.
So Wilda, if you could join us.
Thank you. Stay, Marlon.
Wait a second. Marlon, okay.
Marlon, rest. Hello.
Welcome back.
Thank you.
See you again.
It's nice to be here again. I guess you're not listening today. Okay. I appreciate the opportunity to testify on H 566. I'm here to support the bill's move from expungement to sealing for successful post-charge diversion cases. And a lot of what I was going to say has already been, I think, addressed in the most recent version of the bill. Because I was going to ask you to amend the bill to the effective sealing language, because it's still read like expungement rather than sealing. But it looks like you are doing that in the way that I would have proposed by reference to the effects of sealing in Title 13. I'm supporting sealing because I think it protects second chances while preserving the truth. Sealing is a practical, humane policy because it removes the public barriers to housing and employment, two of the biggest reasons people seek relief from a record. But I support sealing for an additional reason, because expungement can erase evidence that later turns out to matter for safety, oversight, and good policymaking. I've seen this firsthand. In one situation involving a psychiatric survivor who was assaulted by a nurse, the record was later expunged. When policymakers, this committee in fact, later debated stronger protections for healthcare workers, there was no record to point to, so the incident did not make it into the policy conversation. The default assumption became that patients are the ones who assault healthcare workers. The missing record mattered for two reasons. One, healthcare workers can also assault patients. And two, the survivor was not believed until video evidence surfaced, and expungement erased the video evidence. That experience is why I believe sealing is safer than expungement. Sealing can keep records out of public view so people can move on, while still preserving an accurate history that can be accessed under strict rules when it truly matters. I do support making sure that prosecutors, Attorney General's office have access to sealed records, just to make sure that if a person is arrested again for similar, that we have a record of that, because it could mean that certain conditions need to be in place to protect victims, particularly in domestic assault cases. I know last year when you took this up, the Department of Public Safety presented statistics that were pretty sobering about the number of repeat offenders in domestic violence cases, even in diversion cases. And so I think that's why I support the effective sealing to include access for law enforcement. I disagree with the blanket statement that expungement and sealing is a distinction without a difference. I think I've laid out why I think there's a difference. Expungement destroys the record while sealing keeps it non-public but available. Even if an internet trace lingers, expungement and sealing still matter because they determine what the government itself can disclose and use. And I think that's really important. So that I think the only other thing that's not addressed by the amendment that has given me pause and is on the inspection of the sealing order and certificate, where I think it's limits it only to the defendant. I mean, you don't define who the person is the subject of the case. I mean, some victims may think they're the subject of the case, but I think you're really thinking to limit the sealing order to the defendant. And I have a question about whether that's too narrow.
So where are you looking at?
I'm looking at page 3, lines 5 through 9. And again,
Is this in draft number 2.1?
let's see. Yeah, what draft am I looking at? 2.4. Looking at draft 2.1.
Yep. See it. Let's see. Yeah.
So I do think that victims should have access to that. I know one of the scenarios, I'm an attorney, so I'm always thinking about kind of the worst case scenarios. And so one of the scenarios I was thinking with expungement is a person gets their assault case expunged, a victim, and they get a high profile job or something, and person stands outside their work with a sign saying this person assaulted me. Now, in an expungement case, you argue that it never existed. And so technically this person could sue the victim for defamation and have absolutely no record to prove the truth of the offense. And as you all know, truth is, a defense to defamation. And so there could be similar reasons why a victim would want to have access to an index that proves the truthfulness of their accusation, or just for records purposes, for restitution, or you never know, for something they need to prove in connection with that. And so for that reason, I'd like you to consider, I ask you to consider perhaps including victims in some way access to that index. Thank you very much. Appreciate your time.
Thank you. I appreciate that. 'Cause something I hadn't thought of before, the victim piece of it. And I think for me, it gets who identifies the victim. Is it clear? Like, because I forget what it was that we were just looking at a law where like people could not self-identify themselves as victims, but so that's what I'm worried about, is like it just opens up. Like I was traumatized by this or emotionally harmed by, you know what I mean? Versus the direct income victim that was involved in the incident. So
Yeah, I had the same question to myself, which is why my it's not fully fleshed out, the question to you about whether victims should be allowed to, and how do you define victim? I know that there's certain parts of the law that do define victim. I mean, I think there are very few crimes that are victimless in our books. There are some, but very few that are. So I think it's not a problem without a solution.
Yeah, go ahead.
I don't know who this is a question to, but I'm pretty sure we put some exceptions to accessing sealed records for attorneys outside of a criminal context, like in a civil context, that I think would maybe be a relief in the exact example that you're using. So like they can petition the court to have access to that sealed record for an affirmative defense or like a defamation suit. And so I'm wondering, does that kind of alleviate your kind of I know that's like the worst possible example, but I think there are at least some avenues to get
Yeah.
access to it, at least in a civil context.
Well, like I said, I just got handed
Yeah.
this, and so I haven't really cross-referenced it with Title 13.
Yeah.
And so I'm not sure, but I also think that your example assumes the person has an attorney, and attorneys are very hard to come by. In Vermont particularly, I find it, even with money, it's hard to find an attorney to represent you. And so I would prefer, in the best of all worlds, that person wouldn't have to hire an attorney to get access to the record.
Yeah, go ahead, Barbara. Yeah, I was just looking.
Do you know what?
Yeah, I'm looking at it right now on this.
I don't remember. I can.
So I too am intrigued by the examples that you gave about why this is really important to the victim. I'm wondering how to sort of safeguard giving the victim access and not undoing what the sealing is trying to accomplish in terms of the second chance.
But I see the second chance as being able to say no, like if you have a previous conviction. So it doesn't mean, I think people who do their time and complete their sentence, they shouldn't be prevented from getting housing and employment and all of those things. So that's why I like the idea of sealing it for those purposes. But I don't think the person necessarily should be protected from all consequences of their actions.
No.
And that is a victim speaking out. That's just, a victim should have the right to say whatever they want to say.
But your example of the victim, like going to the workplace and I was just thinking that would be hard. I mean, I get.
It's happened. I remember the basketball player, Quentin Daly, graduated from USF, was accused of rape while they were at school and pleaded out or whatever, went away, and first time showed up at an NBA game, nothing but, protesters out there with signs, and he had a very short-lived career in the NBA. So it happens, and that, we have to live with the consequences of our actions.
True. I mean, it feels.
But he wasn't, he didn't get, he could still get housing and employment.
And it's not right. I get the public safety concerns. I get the trying to not make it harder to convict somebody of a future crime. I'm trying to figure out how to, what you said was very powerful. Sealing is good because it's a second chance and the truth. And I was like, that is great. How do we keep both of those?
I think this bill gets really close to doing that. I just frankly don't like destroying government records.
I don't like destroying it.
I'm not a hoarder in the sense, but I'm kind of a digital hoarder, So, I don't really throw much digital evidence out because you never know. You just never know.
Ask one more question.
Yeah, Karen and Angela.
So my piece with it, just for context, so this bill is just on the post-charge court diversion. And so I feel like if we were to look at this question, that we need to look at it with the whole sealing regime, not just with post-charge. So I'm hearing this and I'm hearing a need. I'm just wondering if this is the vehicle or we need to look at some other vehicle to address it more fully.
Where have I heard this before? This is bringing me back to H5.
I know. I was like, do I want to be the one to say that?
Exactly.
Somebody else said that instead of me.
Well, yeah, it was gonna come from you. So yeah, so I hear you. I don't know what your vehicle is, but I do hope that someone drives that.
You know. Angela, then you.
Well, I was gonna go further down this road. Just curious I'm not sure that I understand the, what you envision the victim use of the records would be. What would
Establishing that it occurred. If there was anything having to do with restitution or something, sometime down the line where they might have to prove they had been victim of a crime.
Yeah. So
School, employment, whatever, missing work because of a flare up or, PTSD or anything like that.
Thanks.
Yeah, I don't think we really have it covered yet. So we'll need to look at it again. At least I haven't, my quick review unless I missed something. Did you find?
I think 13 VSA is 7607 subsection C for exceptions.
Subsection C, yeah.
Yeah, that's a good,
Obvious,
that's a good section, but it
but-
has some,
It's not perfect.
Yeah.
But I think that in at least that extreme example, I think that in a civil case, or no, criminal case too, like I think that a defense attorney or a civil attorney could access a sealed record by petition to utilize in something like a defamation suit or something like that. Or like in other, but it's in court, and I agree with you that that doesn't cover some of the other thoughts around the victim accessing the record. But it does open up a big can of worms to be able to let a victim access a sealed record and not undo some of the second chance benefits that you get from a sealed record. So I don't know. I think you'd have
But
to.
if it's in a court, I mean, if it's in a case, I mean, if it is actually narrowly for defense or something like that, that and requires the party to actually seek to have the sealed record used, which we kind of have that part. But
That makes sense. I think I understood the testimony to be you want a victim just to be able to have access to the record no matter what.
yeah, I think, yeah.
That's
Well, that was my broader
Yeah.
point was you've limited to the defendant. Why aren't you including the plaintiff, or not the victim? I was a civil trial attorney. So
Yeah.
how can we get, and then I gave you the example
Yeah.
of, extreme example, I admit, but not out of the,
No.
yeah. So like I said, you just incorporated 70, that Title 13 provision, and I haven't looked at it in depth, but I support the bill. I like the direction it's going, and I appreciate the changes.
Thank you very much.
Thank you.
I appreciate it. So I'm going to the last order of business today. Well, actually, let me just ask. So for this bill, we have just the additional language for the pilot. And I'll try to get that out to everybody today so that people have it overnight. Are there other people we need to hear from? Anybody else we need to hear from on this, or you think we'll be ready to vote tomorrow morning? I think this is the only thing we're going to need to vote on tomorrow. Just really quickly, my thinking on it, looking at, we have.
About this before you move
Yeah,
on? or-
go ahead, yeah.
No, it's just that, and I know that it wasn't here, but we had two different elements. We have a strike all and then do we have a preference or?
I think it's short enough to strike off.
Okay. Right, so I just wanted
I
to,
suggested that to her. So 744 Act relating to procedures for arrest without a warrant, that language is going to go into the miscellaneous bill unless I didn't get the implication that anybody was opposed to that in here for that solution that we had. And the same with.
That was just one line.
That was the one line we're striking. Right.
Striking and
Also, act relating to permitting public access to electronic criminal case records. I didn't see any controversy by witnesses or opposition in here. I was thinking of, on that one, putting that into the miscellaneous bill as well. Part of it is that means fewer bills, so we don't, I know we're live, I'll say it anyway, so we don't freak out our friends in the Senate Judiciary of how many bills we're sending to them. It would be like 2 less bills.
If you were.
yes.
Anne would have nailed me on that one too. Anne would have absolutely caught that. I would have been in trouble. So tomorrow though,
Nobody knows which Ann you're talking about. We're live.
yeah, no. So we're in, after the floor, we're gonna have a little time to take up another bill, 5. Let's see what the number is. It's another fairly compact bill. Just bear with me for a second. I'll tell you what it is going to be. Wait a second. It's miscellaneous changes to the abuse protection order statute 8628, and we'll have Michelle and Charlie and maybe Kim, and we'll maybe need some more testimony after that, but that's also one that might be so compact and uncontroversial. I think we'll find out tomorrow that one might go in the miscellaneous bill, or we'll deal with it separately. But that's after the floor tomorrow. The one other thing is next week is looking like it's going to be a very busy week. We got a lot of looking at budgets, requests of all of the various entities that we deal with, and the Attorney General's office, Vermont Justice Council, the Center for Crime Victim Service, Vermont Network, Attorney Generals, state's attorneys, sheriffs. So we're fitting that in, but also doing the public safety hearing on Wednesday morning and starting with some of the bills related to public safety. That would be pretrial supervision and the no-show bill. So I just wanted to flag that I was also thinking to fit one more person in tomorrow at 1:00 for a half hour. Go over, and that would be Big Hartman, having her back for her to them to focus on their budget requests. So if they are available, we'll be doing that tomorrow at 1, but it'd be a short afternoon. Unless people want to stick around and talk about animal cruelty bills. We'll go off live and we'll be back as soon as I can get Ann Donahue and Michelle over here. And